Say thank you to everyone for coming along today. I know term 4 is one of the busiest terms, so we do appreciate you joining us here today. So welcome to today's workshop, using the Human Rights Act to protect the rights of students with disability in Queensland. This is a bit of a co-presented workshop between CRU and QAI. I'm Ainsley Robertson. I'm fairly new to the CRU team if we haven't met before. Just letting you know that I'm a consultant with the Families for Inclusive Education team and very proud now to be a member of the team here. I'm going to commence first with our Acknowledgement of Country. So I would like to commence the workshop today by acknowledging the First Nations people as original inhabitants or as the traditional owners of the land on which we are meeting on here today in Brisbane and wherever you are. And I acknowledge all elders past and present. So I'll tell you a little bit about CRU first and then about our two co-hosts. So hopefully my screen's being shared there. So if this is the first time that you've come along to a CRU event, welcome. I know that there's many here that have been to many before, but we just like to let you know a little brief bit about CRU. CRU has been around for approximately 30 years now and been working throughout Queensland, supporting individuals with disability and their family members. So CRU exists to support the development of leadership and authentic change, which enhances the possibilities for people with disabilities to belong and participate to community life. So that's one of our key aims, and you can see some more there on the slide as well. So today we have the fabulous Emma Phillips, who is Principal Solicitor and Deputy Director of Queensland Advocacy Incorporated. Emma's work at QAI includes individual advocacy as well as law and policy reform. And we also have Nikki, who's beside me here at the moment. Nikki is a parent of a son with disability who's at a mainstream school. So she's living it and breathing it as well. And Nikki works as education advocate for QAI and assists families of students with disability to navigate Department of Education systems and use other methods to resolve other issues as well. So they're going to be sharing their wonderful knowledge with us today and helping us out with what sometimes is a bit of a complex side of the education story. So before we commence today, I just want to go through a little bit of housekeeping. Thank you. I think most people are still on mute. We will ask you during the key presentation between Nikki and Emma to remain on mute, but please be part of the chat. We can't do the breakout rooms today due to the nature of the content and a number of people here, but please put in any questions or comments that you have in chat. We'll be keeping an eye on those and feeding ones that we think we can butt in with Emma and Nikki along the way. And also if there's questions there that we think, oh, we'll address those and need a bit more time at the end. So we're going to break towards the end of the session, which will be probably a little bit before 11 o'clock. And have that live Q&A time. So that might be me asking some of the questions that have come up in the chat. And hopefully too, we'll be able to just do some video questions as well live with you that we can have the participants asking the questions as well. We might just ask you at the end to do that little raise hand signal that you've got there should be on the bottom of your screen on your toolbar, and then we'll know who's needing to ask a question at the end. We are recording today's session, so it will just be the key content though that Nikki and Emma are sharing that we keep. We trim everything else that's about the participants or the question and answer time. So just remember that as well. Just a reminder to, if you could put your mute on, we've got a few here and I'll just see if I can mute everybody. There we go. All right. Is that a little bit better? Just a reminder too that we do have a individual consultation service here at CRU. So if it's something a little bit more personal, I'll talk more about that at the end. You can always give CRU a call and we can have a chat to you or have a chat with QAI as well. All right, I think without further ado, I'm ready to pass on over to the fabulous Nikki and Emma. So thank you. I'm going to wheel out and we're going to try and do this as smoothly as possible and let Emma come in.
Good morning. Thank you everyone for attending today. I'm going to speak first and hand over to my wonderful colleague, Nikki, who I think some of you know. Before I start, I would also like to acknowledge the traditional owners of the land on which we're meeting today in South Brisbane, the Turrbal and Yagara people, and pay my respects to their elders past, present and emerging. I'd particularly like to acknowledge and pay my respects to Australia's first people with disability who have experienced some of the most significant human rights violations in our country's history, and express my sincere appreciation that their cultural rights are specifically acknowledged and find protection in the new Human Rights Act that we're going to be speaking about today. Just a very quick disclaimer before I begin. So we will be speaking about and providing some general information about laws and legal matters. We're not providing legal advice, so our presentation shouldn't be treated as such. This is just the next slide just provides a brief overview of what we're going to be speaking about today. So I'm going to take you through a brief overview of the human rights protections available in Queensland with a specific focus on the right to education, what that looks like and what that means. I'm going to cover the avenues of complaint for human rights breaches and discrimination, including some of the potential costs and risks associated with pursuing a legal avenue. I'm then going to hand across to Nikki, who's going to address the other avenues available for resolution of issues with school. Oh no, sorry, I'm going to touch on that as well. And then I'm going to hand across to Nikki, who's going to speak about options to achieve systemic change and improvement and cover off on some of the resources that are out there to ensure you're aware of what some of the fabulous resources, many of which have been developed by CREW. As Ainsley said, we'll then have an opportunity for questions at the end. So to start with the human rights protection in Queensland and the avenues of complaint. So we have, and the focus of today's discussion is on the Human Rights Act of 2019, which actually commenced, the obligations under that act only commenced from the 1st of January this year in 2020. We have had for nearly 30 years now protections in place at both the state and federal level that protect the rights of all people against discrimination in particular areas of life, including in the educational sphere. So we've got the Anti-Discrimination Act of 1991, which is the state legislation. And we've got the Disability Discrimination Act of 1992, which is the federal counterpart. We also have some standards made under the Federal Act, and the relevant one for today's purpose is the Disability Standards for Education, which delves into a little bit more detail and is a little bit more prescriptive regarding some of the rights contained in that federal piece of legislation. At state law, education is also regulated by the Education General Provisions Act of 2006. So I'm going to start by just speaking about and giving you a brief overview of what the Human Rights Act 2019 is, what it says and how it might be useful when we're considering the rights of students in Queensland schools. So as I mentioned, the obligations did only commence in from the 1st of January this year, but the Act actually commenced in 2 phases. So it started from 1st of July last year. And at that point, what was known as the Anti-Discrimination Commission of Queensland was rebranded. So they renamed it as the Queensland Human Rights Commission. The Commission kept all the same functions that it used to have. So it still maintains its jurisdiction over the Anti-Discrimination Act, but it also assumed jurisdiction over this new piece of legislation, the Human Rights Act of Queensland. And there's really a lot of relevant interplay between those pieces of legislation, and I'll drill down into that detail shortly. I thought the lead time up until the 1st of January this year was a really helpful thing, because we had 6 months from the time the Commission was renamed until the time people could actually start to bring complaints under the Human Rights Act to the Commission, where there was a lot of time for some educative work. And the Commission, I think, did a great job of making sure that that all the that both individuals and also the organisations and bodies that would be affected by the introduction of the Human Rights Act were aware of what the Act would mean for them and how they could ensure compliance with that Act. So I think that was really, a really helpful thing. And we did see a lot of training rolled out, particularly within state government departments about what the Human Rights Act does mean. That said, as we will get to it, certainly we weren't expecting the Act to be a panacea. We weren't expecting it to be seamlessly implemented, but there certainly are still some really significant problems with regards to the human rights literacy within government departments. And we're going to focus today on the Department of Education, but sadly there's still a significant way to go in our view before we can really say we've got a really thriving human rights culture in Queensland. So the Human Rights Act, it protects human rights. So there's no artificial intelligence, etc. rights contained in it, and they're considered to be the basic rights that belong to every person, regardless of their age, their race, their sex, their social status, or any other characteristic. And it protects the human rights of all people in Queensland. So that's everyone in Queensland. You don't need to be a resident or have a particular citizenship or visa status to find protection in the Human Rights Act. Now, it binds public entities, which is a legal term, both core and functional public entities. And what that means, core public entities are essentially government departments and bodies. So they'll include the Department of Education, relevant ministers, all the state government ministers, public officials, servants, etc. So they're what we think of when we think of Queensland government. Functional public entities, and that is defined in Section 9 of the Human Rights Act, and that includes entities that are discharging functions of a public nature when they're performing functions for the state or a public entity. So they're the entities. It might be, for example, a prison that is run by a private company, but they're essentially doing that function on behalf of the state. So to confirm, complaints under the Human Rights Act can only be made against public entities. And in the education context, that really means Department of Education, including for students who are schooled in state and high schools. There is the option for organisations to opt in, and we're quite proud because Queensland Advocacy, our organisation, has been the first entity to opt in, to be bound voluntarily by the Human Rights Act. We're hoping a lot of other organisations will opt in, because the more organisations that are bound, the broader the coverage. Obviously, the further we are to having a proper human rights culture in Queensland. Private schools are not covered by the Act. They're not bound by the Act. And that was really a sticking point and a contentious issue when the bill was being debated. But and while that issue hasn't yet been tested, it is made quite clear in an example provided in Section 9 of the Act. And it says, a non-state school is not a public entity merely because it performs functions of a public nature in educating students because it is not doing so for the state. And that is provided notwithstanding that private schools do receive some and often quite significant state government funding. So I just wanted to clarify that point. As we understand it at the moment, private schools are not covered by the Human Rights Act. They are still covered by the discrimination legislation. Public schools are bound by both. The legislation establishes a dialogue model, so it essentially binds all three arms of government. So all new and existing legislation is scrutinised for compliance with the Act. The courts and tribunals are required to interpret legislation in a way that's consistent with the Human Rights Act. And it also binds the administrative arm. So public entities have to consider and give proper consideration to and not limit human rights in making decisions. One of the good features of our Act in comparison to other jurisdictions, so there's a Human Rights Charter in Victoria, which came into force in 2006, and a Human Rights Act in the ACT. They're the only other jurisdictions with human rights legislation at this time, and there's no federal Human Rights Act. And our Human Rights Act in Queensland is the first Human Rights Act to establish a complaints mechanism. So by rebranding the Anti-Discrimination Commission, as the Human Rights Commission, that has created an accessible complaints mechanism where people can go and bring their human rights complaint for consideration. And that's not found in other jurisdictions.
Excuse me, Emma, just had a question come through just to clarify that. It's from Rachel. Private schools, so can they discriminate and a complaint can't be lodged with the Queensland Human Rights Commission? Is that correct? Or
that's an excellent question. Thank you, Rachel. So you can still, and this has been a point of confusion. You can still absolutely lodge a discrimination complaint against a private school at both state and federal level, but you have to go under the discrimination legislation. So you have to, if you're bringing it to the Queensland Human Rights Commission, it can be made under the Anti-Discrimination Act, which has always been a tool in the toolbox of parents for bringing these sorts of actions. But if you're dealing with a state school, a state government school, you can also consider whether you have a Human Rights Act complaint to be made as well. And it is a little bit confusing because it's now just one complaint form that the Human Rights Commission has that covers. So if you have a look at it, it's available on the QHRC website. You actually tick whether you've got discrimination issues or Human Rights Act issues. So it does cover both pieces of legislation. But it's only if you're in a public school that you can potentially that they'll potentially consider accepting a complaint under both pieces under both acts.
Thank you, Rachel.
Yeah,
I
thank
had a few
you.
little questions, but I think most of those have been answered. Rachel, just pop up anything else that you're not too sure of, and others as well.
Absolutely, yeah, and anyone else, please. Thank you. And I've just I've noted on the slide, so it protects a range of human rights that Australia has agreed to protect in international law, and I'll discuss that a little bit more shortly. Most human rights are individual, some, such as cultural rights, are considered to belong to groups. Now, I hope you can read this, but what it is just a table where we've included the rights that are protected in the Human Rights Act. So not all rights are protected, but there's a really good broad range of civil and political rights, which are the rights at international law that are articulated in the International Covenant on Civil and Political Rights. To be honest, that was what we were expecting to get when I was really involved in the 5-year campaign that did lead to the enactment of this act, and we were only expecting to get those civil and political rights. We certainly asked for a lot more, but we weren't holding our breath. So we were really happy to get the right to education. It is protected in the ACT, so there is some precedent for it in Australia. But we were very, very surprised and very pleased to have the right to health services as a second economic, social and cultural right included in the Act. And so they're the two rights. Traditionally, governments have some concern about committing to the protection of those rights because they're potentially the costly ones in terms of resourcing. So as you can well imagine. So I think that's a really positive thing. Our Act is very, very young, so we're yet to see the full potential of those rights, but we're certainly actively using and relying on them. And I think it's also important to recognise that there is a lot of intersectional discrimination and disadvantage. So for many people, they're experiencing a violation not of a single human right, but they're experiencing conduct that engages multiple human rights at once. Moving on now to the right to education. So I've just put, this is actually the text that's drawn from section 36 of the Human Rights Act. And it's, I've put it up on the screen for you. So the first limb is that every child has the right to have access to primary and secondary education appropriate to the child's needs. The second limb is every person has the right to have access based on the person's abilities to further vocational education and training that is equally accessible to all. I don't particularly like the wording of this section. It's not how we would ideally have had that section drafted, and we did make some submissions when the bill was tabled in Parliament, it went to a parliamentary committee inquiry, and we made submissions, written submissions, and appeared at the public hearing as witnesses, and made some really extensive submissions about our concerns with that particular wording. While noting, as I've said, we were really supportive of having the right to education protected. I think that's a wonderful thing, but these words we were a little bit concerned about. We're not the only ones. There was a lot of concern, certainly by CREW, other organisations working in this space, and there was a lot of attention and focus given to this particular right, quite disproportionately in comparison to some of the other rights contained in the Human Rights Bill that became the Act. Now, this right, and the bill generally did pass into law in substantially in unamended form. So basically, what we had in the bill is this particular clause that became Section 36. I think the particular concerns was in subsection 1, that first limb appropriate to the child's needs. And that was a really valid concern in light of some of the really significant problems we're seeing in schools that aren't delivering on the promise of inclusive education for all students with disability. And so we were certainly quite concerned that wording might give some basis to further entrench separate arguments for separate schooling, or actually be counter to what we're ultimately advocating for. The Department of Justice and Attorney General responded to the quite significant concerns that were raised, stating that in addition to Section 15 of the Human Rights Act, which says that all rights are intended to be enjoyed by all people without discrimination, Clause 12, which is now Section 12, clarifies that the human rights are in addition to other rights and freedoms. So it means that obviously it doesn't erode from any of the other rights that we had at that time. It's still not ideal, and we've got to work with what we have. But I think the explanatory notes to the Act, international law, drawing on the Convention of the Rights of Persons with Disabilities in particular, certainly gives us a really good basis when we are arguing this right in matters before the courts and tribunals to argue for an interpretation of this provision that is consistent with that body of law. And so that's where we're at with that. And as I mentioned, the right to education has some really significant origins in international law. I won't go through all of these because of time, but I do want to note Section 12, as I've mentioned. So human rights are in addition to other rights and freedoms, and they do specifically include rights under international conventions and international laws. So that's specifically stated in Section 12 of the Human Rights Act. So it draws in all this international law. And Section 48 of the Human Rights Act says that international law and the judgments of domestic, foreign and international courts and tribunals relevant to a human right may be considered in interpreting a statutory provision. So it specifically says when you're considering what a section of the Act means, you can look to this body of international law and what's come before the Human Rights Act. So I think that's a really positive thing, and that really helps us. So we've spoken about what public entities mean, so potentially the respondents to any Human Rights Act complaint. Now they've got really two types of obligations. So they have to, under the Human Rights Act, they're obliged to make decisions that are compatible with the human rights that are protected in the Act, that list of rights I had in the table earlier. And they're also obliged to give proper consideration to relevant human rights in making decisions. And this means they have to actually identify the human rights that could potentially be affected by any decision. And keep in mind, these aren't just only really big decisions like, okay, we're expelling a student. These are anything we can point to that is actually a decision made by the public entity. So they've got to actually identify the relevant human right, and they have to consider and turn their mind to whether the decision would be compatible with human rights. I've put up a few cases there. These are cases from Victoria. We don't yet have, we've got hardly any case law yet from Queensland because the Act's so new. But these certain children cases, they really did establish in the Victorian context and will be relevant in decisions for Queensland by analogy. The importance of giving proper considerations to human rights in making decisions. So that second requirement, and not just acting compatibly with them. And I think this is really, important because we're hoping this is going to lead to overall better decision making within governments and functional public entities, and clearer, more transparent decision making around issues that do engage human rights of students. I think families, parents, advocates have a really important role to play in raising human rights issues with departments and reminding them of their obligations under this Act, and helping them to understand for the relevant student what an outcome that does consider and respect human rights looks like. In Victoria, we've seen their charter, which has been around for a lot longer, used as a basis to require different departments, including the Department of Education, to develop reference guides and training for staff and students, which has really fostered the development in that state of a human rights culture. And I think that's a really powerful thing, because we do know human rights are best protected by a culture that is a human rights culture that understands and respects human rights rather than litigation. Just very briefly, limits to human rights. So at international law, some human rights are regarded as absolute, for example, the right to life. Under the Human Rights Act, no rights are specifically considered absolute. So they are allowed to be limited, but only after careful consideration and only in a way that's reasonable, that's necessary, justifiable and proportionate. I think, and we're yet to see this, but I think that rights that are regarded as absolute at international law, it's going to be difficult to see a situation in which they would reasonably be limited in their application in Queensland. And as this slide shows, this comes from Section 13 of the Human Rights Act. Reasonable limits can be placed on human rights, which may be justified in a free and democratic society based on human dignity, equality and freedom. And that we use what's called a proportionality test to determine whether a proposed or a limitation that's been applied is reasonable and justifiable. That looks at the nature of the right, the purpose of the limitation, the relationship between them, whether there's less restrictive and reasonably available options, the importance of the purpose of limiting the right and the importance of safeguarding it. The Human Rights Act does permit decisions and actions not compatible with human rights to be made if the decision maker could not reasonably have acted differently or made a different decision because of the other law.
Excuse me, I've just had a question come through, a parent, after some clarification. There's a bit of a chat around it. So if you're lodging a complaint against the school for discrimination, a discriminatory decision they've made, is it best to bring it under the Discrimination Act or the Human Rights Act? Is that a too big question to ask at the moment?
Look, it's a very good question, and actually I'm just about to go into complaints mechanism, so that might hopefully will provide some more clarity. But I think, unfortunately, there's no sort of stock answer to that question, because it is going to depend. It is going to depend on the factual circumstances of the case, and we do. Discrimination has both direct and indirect limbs to it, which we don't have the time today to go into those details. But I'd be certainly happy to be contacted with specific questions, and I know Crew also has the individual assistance service that Ainsley mentioned at the start. But I think it really will depend on the facts of the case. For many matters, discrimination law is more limited because it only protects actions taken in specific realms. But within education, because that is a realm where an activity where discrimination law applies, it's really going to turn on the circumstances of the matter. And you can certainly, if you're dealing with a state school, you can certainly make a claim under both pieces of legislation together. Whether the Commission agrees and accepts it under both pieces or only accepts it under one is obviously only just over half of complaints that are made to the Queensland Human Rights Commission are accepted as coming within one of the pieces of legislation. So yeah, that's probably, though, would depend on the facts of the matter.
Thank you, Emma.
Thank you. So going on to complaints mechanisms. Now, Nikki's going to cover off on the first part, which is the first step that's required under the Human Rights Act. And this isn't required for discrimination complaints made under the Anti-Discrimination Act, but you need to first raise the issue directly with the public entity. So I won't touch on that too much because Nikki's going to cover that. But unless you can show that it's a really urgent matter, the public entity needs to be provided with 45 business days, so about 9 weeks to respond. If they don't respond, or if they provide a response that you don't think is appropriate or satisfactory or adequate, you can then you are in a position where you can make that complaint to the Human Rights Commission. And there's a 12-month time frame for making complaints that applies under both the Anti-Discrimination Act and the Human Rights Complaint. Now, as I said, about just over half of complaints are accepted. The Commission's usually quite quick at considering whether to accept a complaint or not. At the moment, they're taking up to 70 days because they've really been hit with a lot of COVID-related complaints. So there is a bit of a delay at the moment. Usually it's within a month that you'll find out if your complaint's been accepted. So it gets considered by a conciliator. And if it's the decision about whether to accept a complaint isn't based on whether they think your complaint would be successful if you ultimately proceeded to have it heard and determined by a court or tribunal. It's about whether it's considered to be a complaint within the parameters of the legislation. If it is accepted, they schedule a conciliation conference, and so that's a confidential conference that's presided over by a conciliator of the Commission. They can be really constructive opportunities to try to resolve a matter confidentially, and for both parties to share their concerns around what's happened and the outcomes they're seeking to resolve the complaints. Now, they're certainly not always so positive, but they certainly depend. I think the closest thing is to describe them properly as like a mediation. And so ultimately the conciliators, they're really good and really skilled, and they will try to help the parties to reach common ground, but ultimately they depend on the parties being able to reach an agreed position to resolve the matter, and that's not always possible. If the matter doesn't settle and it's a human rights complaint only, that's really where that process with the Commission ends. There is an option for referring discrimination complaints that don't resolve to the Queensland Civil and Administrative Tribunal, and under Section 75 of the Human Rights Act, there is power for the Commission to say, look, this complaint actually could more appropriately be considered a discrimination complaint, and they can sort of almost bundle the issues and send them through to QCAT together. But I think I'm disappointed that that's where Human Rights Act complaints stop at the when they're taken to the Commission. I think it would be great if there was that power to seek a referral of an unresolved complaint on to QCAT for determination. There's also an option. I won't go into this in too much detail. It is quite legal and technical, so it's something that's really, I definitely encourage you to seek some individual legal advice if this is something you're considering. But there's an option to include your human rights complaint as part of another cause of action that you've got, so a breach of another piece of legislation, and have it determined by a court or tribunal on that basis. And I can see Crew's offering to send this information out, which is, yeah, great. Thank you very much. So it's quite, that's the complaints process in a nutshell, but it is quite complex. So certainly happy to answer any further questions at the end. I just wanted to touch on, before I hand across to Nikki, the costs and risks associated with taking legal action, because I think that's something that's going to be of a lot of interest. In terms of financial cost, it's free to make a complaint to the Commission. You don't have to pay a filing fee. But there can be some really, really significant costs in terms of emotional costs, time costs. Often we find both the Queensland Human Rights Commission and QCAT are designed to be, forums where people can represent themselves and advocate for themselves, or if you're a parent, advocate for your child as their representative. In practice, we find a lot of respondents when they receive a complaint, they do seek legal advice and they do seek the leave of the Commission or the tribunal to have legal representation. Now, that won't always be approved, whereas if you're an individual complainant wanting legal representation, in my memory, we've never had that request to represent someone denied. So the Commission certainly will look favourably on an individual who wants some support, and you can also have a support person with you at that conciliation. But it can be a daunting process, and when you've got a lot on your plate and you're juggling lots of different balls in the air, to go through that process of writing out your complaint, submitting it after those initial steps of writing to the department, attending the conciliation conference, making sure you have your relevant materials and your relevant details with you, negotiating any settlement. It can be quite a time-consuming process. We certainly at QAI, we are limited by our funding, and we're a community legal centre, so we have got quite limited human resources, but we do the best we can to assist at as many of those conciliations as we can. But in terms of other costs, you can go through that process. You put your complaint in, you absolutely believe in your complaint, and the Commission decides not to accept it. So there's that risk. There's also the risk that you can go through a conciliation process that's not affirming and not therapeutic in terms of talking through the issues, but is actually incredibly frustrating, and you feel like you're hitting a brick wall. And that's I think that's can be a really frustrating and a really demoralizing experience. That said, I think the significant majority of complaints that go through the conciliation process are not those experiences. I think a lot of people do find that process is a really empowering one and a really important one. In terms, though, I think we need to be really clear that where there's a complaint made against a school, where you have a student that is still a student of the school, there is a real risk that initiating legal action does contribute to a breakdown of the relationship. So we always try, when we're giving legal advice, and Nikki through the Education Advocacy Service, to try to support an informal resolution of these matters to the extent we can. So sometimes having a stakeholder meeting, writing some letters or emails, and trying to resolve matters before it gets to the point at which a complaint is made. I think that can be really, really important when we're looking at keeping a relationship working and trying to, with a school that where you might have other children, or you might have hopes of a relationship going forward. We'd always encourage sort of litigation as a last resort, while also being very mindful and supportive of everyone's right and the importance of exercising legal rights. So it's that I hope that's not too confusing a message, because I think it's so important to be empowered to exercise your legal rights and to make a complaint about treatment and conduct that's really not okay, but also to be mindful of how that can affect relationships, because discrimination and human rights law is all about the relationships, whether they're educational relationships or employment relationships. So I think that's an important thing to be mindful of. I might hand over to Nikki now.
There's one question. There's a number of questions which will in part be dealt with later, but one question which I did see pop up was about the time frame for making a complaint.
Yes, so 12-month time frame under both Human Rights Act and Anti-Discrimination Act. I saw some comments about unjustifiable hardship, which
we won't be dealing with unjustifiable hardship specifically, but we'll be talking about that broader question about reasonable adjustments.
Yes.
In a bit of a scenario that we'll talk through later.
Yeah, exactly. So just to clarify, unjustifiable hardship is essentially a defence under the anti-discrimination legislation. So even where there is discrimination and there is some modifications or changes that are considered required, the respondent, so the department in this case, has potentially has at their disposal the defence of unjustifiable hardship, saying yes, they would make these changes, but it's just too hard to do. That is beyond what's reasonable to do. But yeah, as Nikki said, we'll deal with that in a scenario. But I might pass across if there's no more questions.
One last little one that kind of pertains to that. It's if a child has been removed or left the school, is that still that 12-month time frame as well for making that complaint? It doesn't change if that child has exited the system or
no. The time frame is in place. It applies irrespective really of where the relationship's at. I should say there's certainly a generosity on the part of the Commission to consider complaints outside that 12-month time frame. So if you, and I think, and very much a recognition and awareness that sometimes for very, very valid reasons, people are not in a position to even consider making a complaint till some time past that 12-month mark. They do have to balance, as with all timeframes at law, the rights of respondents to have certainty about, and be able to access relevant materials in responding to a complaint, etc., and not potentially be looking at complaints from 30 years ago where none of the staff have any knowledge of what went on, there's no records, etc. So just to give you a little bit of an understanding about why timeframes are in place. But the way it works, it sort of stretches back 12 months. So it will consider, because often the complaints aren't a single event, for example, an expulsion, but they might want to cover a whole range of acts leading up to that event or that don't include an event, any pivotal event, but just a whole range of inappropriate actions. And so that time frame essentially reaches backwards 12 months. Under the Federal Discrimination Act, it's a 6-month time frame, which they are looking at extending, but they also, you just sort of have to show why you couldn't make the complaint within 6 months. But that's obviously Discrimination Act only at federal law.
And there's also another question about resources that are available for people who might be taking action through QCAT, for example. And I just wondered, it might be a good opportunity to just describe a bit about Queensland Advocacy's Human Rights Legal Service.
Sure, yes. So we have, QAI has 7 individual advocacy services. 5 of them are non-legal advocacy, and Nikki's service, the Education Advocacy Service, is one of those. We've got 2 legal services, our Mental Health Legal Service and our Human Rights Legal Service, which is our oldest legal service. It was established back in 2008. It is unfortunately a very small service. I supervise the service. We have 1.5 lawyers in that service, and then I do step in and do some casework, but I unfortunately have limited capacity to do as much as I would like in that space. So we, and it covers not just discrimination, but guardianship and administration and other areas that affect the fundamental human rights of people. So we really do try to stretch that service as far as we can, and we've got the lawyers in the service are amazing. It does mean, unfortunately, that at present we certainly try to give advice wherever it's requested. Sometimes you might have to wait 2 or 3 weeks to get an advice appointment if we're really, really busy. Unless it's urgent, then we always try to slot people in. We will try to assist with reviewing or helping to draft a complaint with correspondence, with stakeholder meetings to the extent we're able to, and we'll try to represent at conciliation conferences again to the extent we've got capacity to do so. Where matters don't settle, unfortunately, at QCAT, the tribunal that hears discrimination matters, they can be quite lengthy hearings and require a lot of preparation, and we just don't have that capacity at the moment. So it is really hard in this environment to find free legal representation for those matters, and I think that's a really significant concern and limitation that I wish would be addressed. It's certainly something we raise every time we put in our new funding applications of the need to expand our human rights legal service. Sometimes we can get a barrister through the Pro Bono Connect program that Law Right facilitates. We can put people in contact with a barrister, but it can be a quite hard space to get free legal assistance, unfortunately.
I'm not sure if this one got addressed. It was just a question from Rita here. Be it possible to bring a complaint to challenge an existing state law as breaching the Human Rights Act? Would you need a particular affected individual to bring the complaint?
That's an excellent question. So the model under the Human Rights Act, the complaint-based model, it is based on individual complaints. So you do need a named person that is consenting to having that complaint, or the consent by their legal guardian if they have a guardian appointed. There certainly is scope for laws to be referred for consideration regarding their compatibility with the Human Rights Act. That's sort of a separate part of the Act. I won't go into too much detail about that today, but I'm happy to answer any questions about that on another occasion. But in terms of making these complaints we're talking about, you certainly do need, you don't have standing to just go and say, look, this law is not compatible with the Human Rights Act. Certainly, it is now we have the Act in place, and it's something I'd encourage you to raise with your local state member if you've got concerns about particular laws that are not compatible, because there's certainly now that process in place for reviewing compatibility.
Thank you. You better let Nikki hop in.
Yeah, sorry, I feel like I'm...
Thank you very much, Emma. I just thought those questions just pertain to exactly where we were at. So
yes,
thank you.
Perfect. Thank you.
Yeah, and I note there's a couple of other questions about class actions and things that we could sort of look at, think about at the end of the session. So I suppose I'll start off by introducing myself and our Queensland Advocacy's Education Advocacy Service. So this is a service that supports students with disability in Queensland state schools and in the homeschooling system, where we receive funding from Department of Education, the Disability and Inclusion branch. So that branch has acknowledged that parents who receive independent professional advocacy services may be able to have issues resolved quicker and more effectively with some advocacy assistance. And I'll get into sort of some of the complications that arise, but certainly I do my best. I work 3 days a week in this role, and that's supporting state school students across Queensland to try to resolve issues with schools. So initially, I'll just talk initially about some of the avenues for resolution. And Emma talked earlier about the stress that's involved in these issues. Inevitably, there's a lot of emotion that comes with having our kids in state schools or in school in general, but having them in school and where there's issues that do arise, where they're being neglected or reasonable adjustments haven't been put in place, or where there are continual suspensions, it is a very stressful and emotional time for the kids and also for the families. So I'd really encourage people to join up. And I'm speaking to the converted because you're all here today, obviously linked in with CREW and possibly also linked in with the Queensland Collective for Inclusive Education. They've got a peer support group on Facebook, so I'm sure many of you are on that. But certainly where you do have issues or your students got issues with the school, certainly, creating that supportive network around you is a really critical thing to do. And also I just mentioned, organisations like Carers Queensland can provide, additional sort of counselling support as well if required. So sort of, I suppose, getting that support network is a critical thing in the beginning, being able to share concerns, being able to request ideas through that network, just being able to have a vent occasionally, really critical for us. Obviously, CREW has got the Families for Inclusive Education project, which I'm sure you're all very aware of, and they do also offer individual assistance. And certainly I've referred clients through to CREW for particularly looking at questions of what reasonable adjustments might be put in place, but they do more than that. So certainly, absolutely recommend tapping into those fabulous people at CREW for that assistance. Their website as well has a whole range of resources. So that's kind of, sort of getting that background, getting that support network. In terms of actually avenues for resolving an issue, and some of them are quite obvious. Obviously raising it with the school principal or with the school, with the teacher, and requesting action, whether it be a reasonable adjustment or a way, if you've received specialist advice from a speech therapist or something like that, passing that through and asking that they take action on that. It's very dependent on the school, and I'm sure you're all very aware of that. Your son or daughter's school, their attitude, their culture within the school as to whether they'll, thank you and, welcome the resources and what you've offered or what you've asked for it to be implemented. Other schools, though, will flatly refuse to do that, or they will, say that they'll do it and actually not implement those adjustments or that support. So raising it with the school principal or with the teachers is certainly, should be the very first way to do it. Perhaps verbally first, and then proceeding with a written request. Unfortunately, I kind of get the experience that I have is with clients that come to Queensland Advocacy have gone through these avenues initially, and really they're quite sort of obvious. So again, these issues, if the school doesn't resolve them, could engage with, it's possible for parents to approach the regional offices of the Department of Education and request assistance through there. And certainly most of you are aware that there are inclusive education advisors, there's autism advisors, there's guidance officers, and my experience in dealing with quite a number of regional officers across the state is that there's no consistency with how they deal with issues. There's no consistency as to whether, one regional office might deal with things quite promptly and respond quite promptly. There's another regional office that I've attempted to contact for quite a number of weeks, and just sort of met with, deaf ears, failure to respond to phone calls, failure to respond to emails. So it's not an easy process, engaging either with the school or regional office, particularly, depending on what the school culture is like or the regional office culture and processes are like. So I'd like to be able to paint a sort of happier picture, but there are certainly, and I have to say, like, I obviously deal with quite severe issues where things have escalated to a point where people feel as though they need some advocacy assistance. So hopefully people can come in, in the comments section or something, and give some happier stories. I should say we've definitely had some positive outcomes with the work that we've done. But it does take quite some time. and quite some effort often as well.
Just a question that's come up there that pertains to what that discussion was about. Is it common for a regional office? I know you said they all do things differently, but have you heard of people just sort of ringing up with a query or concern and that sort of being put forward as a complaint and they're provided with a number? That might be a little bit off-putting for people if that's a usual.
Yeah, I've seen more often the opposite happening, where people have actually attempted to lodge a complaint and it hasn't been dealt with as a complaint, but it's just sort of, they might receive a one-line response and the application of the complaints framework and the complaints procedure hasn't, those things haven't been applied. I'm not sure that I've heard it in that opposite direction, where we go to regional office with a query or concern and they turn it into a complaint. The complaints framework, I think it is, defines what a complaint is. And yeah, I mean, it'll be interesting to see what their response is. I would, in some ways, I'd prefer it to be dealt with as a complaint, because then you've got, they've got to follow a procedure, they've got to respond to you, provide you with sort of options if you're not satisfied with the response. But is that usual? Not that I've seen, but that's not, any indication of what is happening. So there's another question that's just popped in. I was at the school when someone called and actually overheard the caller saying that I had called to make a complaint, when it was simply a question on, on who I needed to speak to. Yeah, I mean, the things like that are probably an indication of the culture of the school and more broadly the culture of the department. And, it may be that, the school's feeling defensive or the regional office is feeling defensive and feels as though they need to take that more formal avenue. So I might, and then, so the last dot point on the slide, so the sort of the third and fourth dot points are more the informal ways, I suppose, of approaching an issue. And then we get to the actual complaints mechanism, which is what I've just, and the questions have referred to briefly. So essentially the complaints process, you'll find a lot of information available about it on the Department of Education website. And it looks, it could could be seen as quite daunting, because there is, there's the framework, I think there's a policy, there's a procedure, then there's, various other procedures for dealing with all sorts of other things that all relate to the complaints framework. So, it can be a complex thing, but it also can be approached on a relatively, in a relatively straightforward way. So, and this is sort of step one in taking a matter which relates to, human rights, and particularly the right to education, taking that through to Queensland Human Rights Commission. So, as Emma spoke about, first of all, the complaint has to be made to the entity. So in this case, either the school or the regional office. So the complaints process, I've popped in a link just to the complaints website of the Department of Education. Don't bother scribbling that down. Not only will you receive the PowerPoints, but if you just search Department of Education complaints, you'll come up with that. So again, I've made that note about this as step one in for making a complaint to the Human Rights Commission. And it's always good to include within the complaint that you want it to be treated as a human rights complaint as well. Under their procedure, they should be assessing any complaint that's assessed. They should be assessing whether it's got human rights, that should be considered with that, and whether it might be a human rights complaint, but it's always safest to put that into the complaint. If the complaint is about a school staff member, the complaint gets made to the principal. If the complaint is about the principal, then the complaint goes to the regional office. under the complaints framework, a complaint can be, you ringing up on the phone, but, my advice is definitely put a written complaint in if you're wanting to go through that process. Then it's documented. Now, you should receive a response to it. The framework or procedure has timelines about receiving responses to complaints. I won't go into those because it's variable as to whether the response is received in an appropriate time frame or not. But certainly if you're not satisfied with the response, then there are avenues such as the Human Rights Commission, as Emma spoke about, but there's also the option to request an internal review. So basically what that means is if you've complained to the principal responds to you, you're not satisfied with that response, you can take that then to the regional office and ask that they review the complaint and the response to the complaint. I've been through a number of these with clients and with variable success. But yeah, the other option obviously is the Queensland Human Rights Commission complaint if it is either a discrimination or human rights complaint. But as Emma mentioned, you don't actually need to put in that first step of the complaint to the entity if it's the discrimination complaint.
And Nikki, probably I just wanted to add at this point too, with respect to this making of the initial complaint to the public entity itself. In the explanatory notes accompanying the bill, there is actually guidance around that particular provision in section 65. It says the intention of the provision is to ensure a complainant first attempts to resolve the complaint directly with the particular public entity before making a complaint to the QHRC, which we know. It then says public entities should ensure an appropriate complaints handling procedure, including to deal with human rights complaints, is in place to allow for the early resolution of disputes where possible. So this was clearly Parliament's intention in having this process in place. But as Nikki mentioned, the response received is so variable. And I think, we've had a lot of conversations about this and how ultimately there's a lot of really these microcultures within schools that's often very much dependent on who the leadership team is and the type of leadership that they're providing, that does very much influence how quickly, how well, how genuinely complaints are actually responded to.
Yeah, absolutely. And there's a template sentence. I should have included it in the slides, because there's a template sentence they seem to put within all responses to all complaints, which is that in relation to human rights, I should say, which is that in making this decision, I've considered your human rights and the decision's compatible with human rights.
Which doesn't actually meet the standard prescribed even specifically in the Act, which says they have to actually identify what human rights are, engaged and respond. So it actually is a deficient response, but it's very much the standard, isn't it?
Yes, absolutely. And so, I don't know if I'm speaking for Emma, but certainly in my view, it should be identifying the human rights
absolutely
that are engaged, how they've been considered, how they're relevant, how they've been considered, and why the decision is compatible with those human rights. So
absolutely, and showing that really genuine and proper consideration. So they're not just paying lip service to, yes, you have a right to education, we've considered that, or yes, you have a right to not be treated in a way that's cruel or inhumane, we've considered that and we haven't treated you in that way, but actually properly considering it. And I think that's why I put the links to those certain children cases up, because that's certainly what we would be looking to in litigation around that point, because I think it's really important, that really properness and fullness of consideration that's often very lacking at this stage.
Yes, yeah. And yeah, I was also going to make a comment about that if you're not satisfied with the internal review response, then there are external avenues apart from the Human Rights Commission, there's the possibility of QCAT or going to the Ombudsman. I won't go into those in detail, but in the internal review response, they should provide you with those kind of appeal avenues. So that's that. I'm just checking.
Yeah, that last question there might be a good one to address there, Nikki, because that's probably a very common concern.
Yes. Okay. So the question that's come in is basically fear for reprisal, I suppose, and absolutely. Like, I think every client that I've spoken to is, has that fear of reprisal against their child with disability, or their siblings, or the parent as well, I suppose it's, a complication to this, which you're all probably highly familiar with, is that, our kids go off to school. We're not there. We can't see what's happening. We hear what's happening. And so, yeah, there's always, there's always that question mark of what is actually happening at school. And, the school can deny things. Fear of reprisal. Yeah, I mean, I unfortunately can't offer much. I mean, certainly there should be no reprisal. The complaints framework says it, the policy says it, the procedure says it. There should be no negative response to a complaint. But whether that's, the department or the school will actually comply with that is another question. And then, if you feel there is reprisal, whether that can be proven. So I would like to paint a rosier picture, but yeah, although the things are in, the policies, the procedures, the frameworks, they're all really nicely written. Yeah, it does depend on the school culture and the culture of the regional office, and whether there's going to be simply a sort of culture of compliance, or if they will actually objectively look at a complaint. So
yeah, I can only add, I think that's a really legitimate concern, and I think it's a really good point to discuss, because certainly I was speaking it in the context of considerations around litigating a right, but it is absolutely a consideration throughout the process. And it's there are laws in place to protect against reprisal, in addition to the guarantees of the complaints framework, such as they are, but it's in reality, as we know, that can look very different. So it is a really legitimate consideration and concern that shouldn't have to be a consideration and concern. I think if that is a particular concern, having some advocacy support from the earliest opportunity can be really helpful, because I think sometimes that can and taking there's a saying within discrimination law about walk quietly and carry a big stick, used to critique the fact that discrimination law hasn't really produced the big stick people wanted it to when it was brought in. But I think that taking a softly approach initially and trying to see if matters can be resolved as gently as possible in that early stages, keeping in mind that that's very, very much often not a possibility, and by the time it gets depending on the school's response.
Yeah. There's some more questions around that, that came up about, well, what avenues can we take, if there's further abuse, and there is reprisal, and it's, there are, there's a number of, options available, like those, the complaints processes that we've talked about. Ombudsman's office may well be interested if it fits within, a crime and corruption commission may be interested under certain circumstances. So yeah, so there's a number of things. It's And, you know, it may be that if you've got a particular circumstance, it may be, you know, ringing QAI and requesting an advice appointment with the Human Rights Legal Service. And I should also mention there's other community legal centres as well around Queensland that can also provide assistance. So,
yeah, I was just going to say, there's a question from Deb that just might have a quick answer there, but it's something really important. Just that, you know, all this strain that families go through with do I and don't I, and when they do the extra strain that they get from making a complaint, etc. Is there anybody collecting any data on the well-being of people who pursue these avenues? Is there anything like that in Queensland that's being undertaken or thought about that you've heard of?
So if people couldn't hear that, the question was around if any data exists about the wellbeing of people who make a complaint. Not that I'm aware of. I mean, I can talk from, you know, the experience of my clients, and I know across Australia, CIDA, the Children and Youth
Young people with disability Australia.
Yeah, they've done some surveys of parents, and I'm not sure if it specifically looks at this point, but certainly they've got data around how students with disability are included within schools, and various issues that arise. But it may be something, you know, that, you know, it's probably well worth it. But I can say, you know, 100% of my clients, I would think, you know, all feel as though their wellbeing's been negatively affected by the way their students have been treated in schools and through in trying to, you know, engage with the school or the regional office to fix that. So there's a statistic for you.
Sounds like something we parents might need to advocate for more again too, that data is collected and reported on.
Yeah, certainly, and that's something some of you, or hopefully all of you are aware that the Disability Royal Commission is around at the moment, and I'll talk about it a bit more later on, but certainly it's something that Queensland Advocacy has spoken about with the Commission, along with other organisations, about the need, including just last week when there was a public hearing about in relation to education. It's certainly that issue about data and the need to obtain better data certainly has gone to the Commission as a recommendation from many advocacy organisations. So I might just move on.
Yeah, we're just aware of time because it's already 11:15. I know we've been answering a lot of questions on the way.
But I might just add on that point before we move on. One of the things we have really hoped and expected with the Human Rights Act is that cultural change, which is going to hopefully lead. I mean, it's really early days, so we are yet to see a lot of that happening. But we are really hopeful there will be that cultural change within the department in terms of how decisions are made that will hopefully avoid some of those experiences.
So if you are making a complaint to the Department of Education, whether it to be to a school or to a regional office, just a few little points, which again are quite possibly obvious, but state the issues clearly and succinctly. If you are able to, like if you feel confident to refer to the Disability Standards for Education, departmental policies and procedures, the Human Rights Act, and the other pieces of legislation that Emma spoke about earlier. But in saying that, I recognise that some people, you know, may not feel comfortable to do that, or may feel just completely overwhelmed with you know, their personal well-being, and, you know, aren't able to kind of engage with those quite lengthy documents in order to include references to those. Where you can include evidence of the complaint, that might be something that your child said, it might be photos, it might be you know, emails to or from the school. State what resolutions you seek. And also request that it be treated as a human rights complaint, and a complaint under the complaints framework. I was hoping to have ready to share a sort of template complaint, which is not quite ready, but hopefully within the next month or so, we'll have a template complaint available on QAI's website, so people can use that just as an initial starter, you know, to hopefully help people along the way of making a complaint. And since there's an audience, I just really want to emphasise, as Emma talked about, you know, what we really need is cultural change within schools and within the Department of Education, and the other bodies that govern other schools apart from state schools. Unfortunately, what it seems is that, you know, cultural change within you know, particularly very large bureaucratic entities, you know, really, they won't do it by themselves. It does require the political will. And really, it's, you know, I really like to emphasise the power of communities to create change through networks of individuals and groups who work together to advocate, to make a difference. And certainly, you know, there's the Queensland Coalition, sorry, the Australian Coalition for Inclusive Education, which both CRU and QAI are members of, is working towards that. Queensland Advocacy engages in systems advocacy, so that campaign work. So we do the systems advocacy, the campaign work, plus also the individual advocacy. So I work in individual advocacy, working with individual clients on individual issues, and then other people work on the systems, doing that sort of broader campaign work to try to address the, you know, policy and legislation. So that's QAI's work, and really put out a shout out for the Queensland Collective for Inclusive Education, which is and many of you are probably you know, members of that, or, you know, part of that, or, you know, part of the Facebook group, but they, you know, do some fantastic work around helping to raise awareness of these issues, and to build that political will for the, you know, that social change that's required around education. And just as well, I mentioned the Disability Royal Commission earlier. Such a fantastic opportunity, and QAI's got a fair, you know, we've sort of been engaging in various ways with the Disability Royal Commission, and really very confident that this is a, you know, hopefully get some fantastic recommendations from the Commission, which can then be put in practice. So people, you know, in this, you know, who are listening to this, if you've got a story that should be told to the DRC, to the Disability Royal Commission, please consider going ahead and telling that story to them, so they can use that to learn from and put forward recommendations. That those recommendations won't be that a particular school should do a particular thing for a particular student, but they'll be broad recommendations. So I can't stress enough how important it is to engage with the DRC. That might be a written submission, it might be having a private session with a commissioner, or, you know, there's various other ways as well.
And one of our non-legal advocacy services is a Disability Royal Commission advocacy service, with a wonderful advocate running that service, providing some support and assistance in that space. And there's also other organisations providing that support if you are interested in engaging and would like some advocacy support.
I'm wondering if we've got time for this.
Or should we go to questions?
Have you got?
Might be better to.
Maybe we'd better have to
do some question time.
We were going to run through a scenario and how it related, you know, how the Human Rights Act could be used as part of that. But given the timing, I'll just quickly. We've put a few resources together here. There are, you know, so many more, but you'll receive these. But yeah, there's just a few little links there that might be of interest. but we might just go back to some of those questions.
Scenarios would be good, actually. So
Well,
if we can do a very quick.
Yeah, you want to do that. Otherwise, we could have the questions, and then if people want to stay on at the end, they could do the scenario then. Or do you think you could do a quick one now? Up to you.
I'm just looking at the comments. So yeah, should we just very quickly touch on the scenario, maybe within 5 minutes, and then perhaps we're happy to take questions later as well, if that's helpful. Yes.
Okay. Scenario wins.
Yes, there's lots of scenarios.
So we were going to talk. We just wanted to quickly talk through the scenario of where a school fails to implement reasonable adjustments. I thought of to be specific, we'll talk about a student with a visual impairment, and this is actually an example which I brought up with the Royal Commission last week in the public hearing. It's a school student whose English class, the prescribed text was a novel. That novel was not available in any format that was accessible to the student who had a visual impairment, and the parents had to read and reread this novel, like a whole novel, to this student. So I'll pass over to Emma to initially kind of sort of set the scene in terms of what the law says, and then we can talk through how to approach a situation like that.
Sure. Yeah, thanks, Nikki. So look, under discrimination law, and I think many of you will be familiar with this, there has been this this duty to make reasonable adjustments, and that's relevant to considering whether someone has been discriminated against. Under the Federal Act, we've got the standards which help to explain what reasonable adjustments, and help to provide further nuance and detail around that issue. But I think it's certainly been a very contentious issue, and a lot of the time, unfortunately, what is perceived as being a reasonable adjustment sought is denied on the basis that to do so would impose an unjustifiable hardship on the school. And this has been the case across, in the example Nikki's mentioned, and quite across the board. We're really hopeful that the Human Rights Act gives us a little bit more scope to because we can say, on the basis of that right to education, that there is this clear right that schools are therefore required to ensure students do have the supports and adjustments they need to exercise this protected right to education, and that does include the right to reasonable adjustments. This is yet to be properly. I mean, it's very, very early days in terms of the Human Rights Act, but I think a lot of we are hopeful that some of the limitations that parents have really been facing in that regard when it comes to seeking reasonable adjustments, and the fact that it is in discrimination law, it's always been sort of a negative right, if that makes sense. It's you've got to show you're being discriminated against, and therefore the requesting of reasonable adjustments is part of that discrimination. So you're sort of on the back foot to start with, whereas this here with the Human Rights Act, we have a positive right to education as opposed to a right to protection from discrimination. So we're really hopeful that does shift the consideration and make it more normal to see these sorts of reasonable adjustments put in place.
So in terms of how to take a matter like that forward, obviously, first of all, raising it with the teacher and with the school, and saying, this is not appropriate, as referencing, if you feel comfortable, the various pieces of legislation or policies. Now, hopefully the response that was received is, yes, acknowledge that, and from now on we'll only choose texts which are accessible, or we will provide an accessible form of that text. If that doesn't happen, then putting in a formal complaint, in this case it would be to the principal, because it's a decision of a staff member, Again, if that's not resolved, you can take it through to an internal review at the regional office. Or if you don't want to go through the internal review process, or you want an additional option, it would be then taking that forward to the Human Rights Commission. And sort of, I suppose, just to give you some context about Queensland Advocacy, I assist people through the complaints processes up to the point where it's got to go to another option, whether it be QCAT, the Ombudsman, or the Human Rights Commission. And then if it's a human rights issue or a discrimination matter, I often handball it over to the Human Rights Legal Service so they can provide some advice to the client. So that's kind of what I'm doing now, is passing over to Emma to kind of talk through this situation.
Yes, and look, I think if we can pick up in our scenario, because I think there's just been a great point raised, saying that it's a great example, but that physical disability adjustments can look very different to intellectual disability adjustments. And I think that's absolutely true. And I think in terms of the legal response to a failure by a school to make the reasonable adjustments that are reasonably sought by a family, discrimination law has long had the problem of purpose, where essentially part of the argument there was that
that's a High Court decision.
It went all the way up to the High Court. So it was actually involved the New South Wales Department of Education, and it was a case back in around very early 2000s, and went through the Federal Court and then up to the High Court on appeal. And unfortunately, in terms of the precedent, the sort of binding ruling established by that case, it has been one of the problems for discrimination for students where they've got an intellectual disability or a disability that can result in some can be expressed through behaviours that the school might be responding to in a way that's not consistent with a rights-based approach to that student. So essentially, very briefly in Purvis, it was found that, well, look, the school didn't discriminate against this child who had significant disability, but because by excluding him, because they would have done that for any student with or without disability who was acting in that same way, so that their response, their punitive response to this child was based on the behaviours that he was displaying in school, and that for the school to actually properly accommodate this student and provide an appropriate learning environment for him, it was imposing an unjustifiable hardship on the school and a risk to the teaching staff, etc. So that's actually a case-based example, but it's a scenario we see very, very, very frequently. So where there are where a student is requiring learning to be provided in a different way because of an intellectual disability, or where a student has a disability that impacts upon the way in which they're communicating, and it's not communication that is condoned by the school. The response is often, well, we can't accommodate this because it's too much of a has too much of an impact on the learning of other students, it imposes unreasonable requirements on the teachers. And so what we're really hoping is that with using the right to education, as I said, it takes it in further, that it's not just that students should be protected from discrimination, but they need to be supported to exercise their positive right to an education. And that's where we're hoping there will be that shift. Just reading the, are there other, I'm conscious of, we have one.
There's probably two questions that I saw that we might just come back to quickly. One of them was regarding, I don't know if it's too huge to address today, and it might be something people might want to call QAI about, regarding the class action.
Yes.
And I'll let you go with that one first.
Yeah, I can just give you a very, very brief response to that. So under the Human Rights Act, there is provision for complaints to be made with more than one complainant. So it's got to be the same. You couldn't, it has to be the same conduct giving rise to the complaint, but where you've got essentially, so the same sort of scenario that's leading to the complaint. So I think it would be difficult to make a general class actions, for example, against all state schools for failing to properly include students with disability, or something very general. It's got to be specific to the scenario that led to one person's human rights complaint, but that's where you can join them and bring them together.
There was one other one here, just keeps jumping around my screen. It was just pertaining to a question earlier that was asked about some differences between the state and federal
discrimination
complaint between the two. But yeah, what I might do, if people would like to ask a question for themselves at the moment, if they are able to stay in the room and would like to ask a question, if they would like to raise their hand, and we might be able to see that flagged, and turn your mic off and your video off if you feel comfortable with that.
And while people are doing that, I can respond to that question if you like, regarding the differences.
Thank you. So I was just trying to find the exact wording, but
yeah, sure.
Me. But if you feel as though you've got a
sure, I can. Yeah, no, I can start with that. And if it was your question and you'd like to, I'm not on point, please raise your hand. We haven't, as we said earlier, gone into any detail with respect to discrimination law today, with the focus being on the Human Rights Act. But the manner of making a complaint under the Discrimination Act at state and federal is really quite similar. I think there's under the state, there's pros and cons for either jurisdiction. Under the State Act, you now obviously have the Human Rights Act, which is really significant, that specific right to education and some of the other rights as well, particularly the Section 17 right to protection from cruel and inhuman and degrading treatment. But they're both sort of made to the relevant human rights commissions. They require a written complaint to initiate them. The complaint forms are not that dissimilar. The process is going to a conciliation conference, and if it doesn't resolve for discrimination matters, the option of taking it further. There are some nuances in the legislation that can influence the choice of jurisdiction, because often people will have a choice as to whether to go under state or federal legislation. And under the Federal Act, the reason for the discrimination, the discriminatory reason just has to be one of the reasons for the less favourable treatment, whereas at a state level, it has to be the substantial or the primary reason for the less favourable treatment. So there's some, you've got the disability standards under the Federal Act. So there are some differences as to why you might choose to make a complaint to the state or federal commission, but the process is quite similar. If it doesn't resolve federally, it goes to the Federal Circuit Court, which is a little bit more of a formal and costs attracting environment than QCAT at the state level, although we have seen certainly costs awards made by QCAT in discrimination matters. Was that?
I'm not seeing any reactions come up, but please, no. If you did have something and I haven't seen your reaction, please turn off your mic or video, and we'll just might try and squeeze in one last question.
It's around that often defences come up very quickly when a school's approached with about issues. Absolutely agree with that one. And so you can see that some skills are needed to minimise the chance of that while being persistent with the advocacy. And certainly, absolutely agree with that. CRU's got some fantastic resources around engaging with school meetings, around advocating for your child, and certainly part of that is having a support person present, as Katarina has raised. Or advocate engaged, and there's various other things as well. And I absolutely recommend CRU's resources on these. It's about being prepared for meetings. Ensuring that there's an agenda for the meeting. Ensuring that there are going to be records of the minutes afterwards, records of the meeting afterwards that will be shared in draft format for you to respond and any changes to. Having the support network. I can't quite remember everything that CRU's put in there, but just check out CRU's website. for those advocacy tips.
And their workshops as well. We get wonderful feedback, and I'm seeing the comments come through about congratulating crew on their assistance, and we certainly get wonderful feedback on the crew workshops. So yes, we strongly recommend.
I'm just jumping in here as someone who from crew, just to say, I guess the other side of that is that crew is doing a number of presentations with regional officers about what needs to happen, change at the school level for them to partner with families. And so far, all of those have been really kind of well received, because it's one thing, you know, some of the feedback from parents who've come to our workshops is that's great, I do feel empowered, but I go back to the school and their practices haven't changed in terms of listening to the parent experience. And so, you know, and this isn't a quick thing. Like, I'm not imagining a one-off presentation by, you know, me from crew is going to change some of those entrenched patterns of, you know, kind of stonewalling of families or, you know, defensiveness, etc. So I'm hoping that the department is recognising this is actually a very long-term process of cultural change in terms of valuing first the student with a disability and then valuing parents for their input. So you know, and I guess just to say, you know, I think that message that the legal options are a kind of a last resort, but knowing that and knowing that we can start talking to schools actually about their legal obligations is really important as parent advocates. Yeah, so I guess I just think it's about the strength, I guess, in numbers of on message parents who are clear that their children do have human rights and that we're kind of able to stand for them. So just want to say thank you, but also say that parents can learn skills, but I also think it's about absolutely about schools sharing power with families as well.
Absolutely. And a comment came through before about the importance of education, not just within the departments, but within the change happening within the schools. And absolutely, that's where we're really hoping it's going to happen.
And yeah, and I'll just go back to the, you know, the need for systemic change, the need for social change on this, and you know, that advocacy, that building of political will through the media and through other outlets is, you know, really critical to achieve that.
Thank you. I'm going to pop back in, and I think it shows what great interest this topic has, that we've got most of our participants still here nearly 2 hours later. So a really huge thank you to Emma and Nikki and to everyone who's joined us today. This is a very big area and a complex area, and I'm hoping that, and I'm quite sure that everyone's feeling a little bit more like they understand what's involved and what resources are available. So we do really appreciate your time in amongst a very busy time of the year for them both. Also just wanted to say that, that the message truly came through today. That's really important that we work really hard to try and sort these issues out at school. But it's also really good to know that there are services available for the times when it does get really rocky. So yeah, you've got a little bit of that for you now to think about. And also I put in the chat section about the new I Choose Inclusion that's been updated. So I'll put that in the follow-up email, the digital version link, because some of what Emma and Nikki spoke about today is outlined there in one of the chapters. They actually helped assist write that chapter of I Choose Inclusion. So that may be really helpful too. I think that's everything for today. Just reminding you, as we have already, that crew does a range of workshops, both online, and we're starting to do some face-to-face. So keep an eye on our media and on your emails for information about that. Lots of questions today about adjustments around curriculum adjustments. I'm doing a workshop on that in about 2 weeks' time. So that may help you with your advocacy for those curriculum adjustments going forward as well. I think that's everything today. But just wanted to note too that QCIE was referred to today. They've just updated their website with some excellent resources there for parents. And if you can't find the links to Facebook, within Facebook for their groups, then you could get those off the QCIE webpage as well. I think that's all. So we're going to finish off now, and there's been a couple of personal questions. We'll do our best to follow up on those. We will send out a recording of this session, and also we'll have a look at whether or not we can send the chat out as well. And I think if it's okay if we do a PDF of your slides and put that in our follow-up email. Great. Okay. That's over and out. Thank you everybody for joining us, and we'll see you soon.